Good morning, and thank you for taking the time to join us for this important update. In just a moment, Michelle Beneski, Managing Partner of Surprenant Beneski, will share an overview of the changes related to the Secure Act. She is joined today by Anthony Salerno from Ameriprise Financial. It is important that you understand how both your financial plan and your estate plan could be impacted by this recent law change. First, let's cover some housekeeping notes. During the presentation, if you experience any trouble hearing or seeing the webinar and need to communicate with us, please use the Q&A function. If technical issues persist, please call our office at 508-994-5200. If you have a question about the content we are sharing, please feel free to submit it via the Q&A function at any time. We will save all the questions for the end and answer them at that point. At the end of the session, you will receive a survey where you can express your interest in the next steps, which Michelle will cover before the Q&A. If you are interested, we are also offering several in-person seminars on this topic. Please note that the exact same content will be covered. However, if you are interested in attending, please see the event listing on our website. As background, the Secure Act, which its full name is the Setting Every Community Up for Retirement Enhancement Act of 2019, was approved by the Senate on December 19, 2019, as part of an end-of-year Appropriations Act and accompanying tax measure, and signed into law on December 20th by President Trump. This far-reaching bill includes significant provisions aimed at increasing access to tax-advantaged accounts and preventing older Americans from outliving their assets. Now, to begin today's presentation, here is Michelle Beneski.
Welcome, and thank you for joining. The Secure Act is the biggest change in retirement planning laws since the creation of the Roth IRAs in 1997. Depending on whether you are already taking required minimum distributions, it may or may not impact you, the retiree, directly. However, the Secure Act will definitely impact your beneficiaries and probably impact your estate plans. We're here to help you understand the changes, the potential impact of the law on your estate planning and your family. At Surprenant Beneski, we concentrate our practice solely on estate planning, including estate tax planning, asset protection, special needs planning, and elder law. That focus allows us to keep up with the many changes that occur in this area of the law. My partner, Dan Surprenant, and I are two of only 25 certified elder law attorneys, CELAs, in Massachusetts. CELA is designated by the National Elder Law Foundation and is the only elder law certification recognized by the American Bar Association. Further, I have a master's or LLM in taxation. I spent an extra year after law school to specialize in tax law. That can make a huge difference to our clients because, as you will see with the Secure Act, estate planning often involves understanding the impact of income tax, capital gains tax, and estate taxes on your choices when planning your estate. At Surprenant Beneski, we are committed to staying up to date on law changes that are likely to impact our clients and their estate plans. This is one of those times, and we are reaching out to clients as well as non-clients to raise awareness to this latest development. In this presentation, we're going to try to help you understand the change in the law and how it could impact you, your family, your finances, and your estate plan. This change is much more than a legal change. It's going to affect the ultimate financial value of what your heirs received from your retirement account. We believe all of your advisors, your attorney, your accountant, your financial advisors, should work as a team to help you reach the results you need. To help you understand some of the financial impacts of the law change, we're lucky to have Anthony Salerno, Vice President and Financial Advisor from Ameriprise. We have many clients in common with Anthony. He also believes in the importance of all your advisors working as a team. He will be able to give you some things to consider from a financial planning viewpoint. There are some good changes in the law. Many clients complain that they wish they didn't have to take a distribution because they want to save that money and they don't want to pay income tax. Good news for anyone who did not have to take a required minimum distribution, RMD, by December 31st, 2019, end of last year, you don't have to start taking RMDs until the end of the calendar year that you turn 72. This gives you an extra year and a half before you have to take distributions. So that's good news. Second, you can now contribute to your IRA your whole life. Before, you could not contribute after age 70 and a half. You couldn't put any more money in. Now you can. And last, you are now allowed to invest in an annuity through your 401k plan. You have more options. All of those are good things. The challenges of the new law. One of the best benefits of inheriting an IRA from a non-spouse was the ability to withdraw the funds slowly over the beneficiary's lifetime. This allowed the money within the accounts to grow income tax deferred, which meant it could grow much quicker. Stretching out the withdrawals also allowed the beneficiary to plan withdrawals in a way that minimized income tax. Apparently, the government didn't like all this income tax deferred growth and income tax minimization, so they eliminated the stretch out in most situations. Now, most beneficiaries must withdraw all the funds by the end of the 10th year after the account owner dies. Here's the interesting thing, though. There are no required minimum distributions. The beneficiary can leave the full amount in the account until the 10th year and then take it out all at once. Certain individuals can still stretch IRA withdrawals out over their lifetime. The details on these categories are still being fleshed out. Spouses are obvious. For minor children, it appears that the child must take the RMDs based on the child's age at the account owner's death. But when the child reaches age 18, then the child switches to the new system, and there are no RMDs, just the requirement that all of the remaining funds are withdrawn within 10 years, about age 28. It appears that if a minor other than the account owner's child inherits the IRA, distributions are subject to the 10-year rule. So this would be if you're leaving your IRA to your grandchildren, they will be required to take that money out over 10 years. Certain disabled individuals and certain chronically ill individuals and beneficiaries who are not more than 10 years younger than the account owner can all continue to stretch distributions out over their lifetime. In order to determine if your estate plan is impacted, you first have to identify the reason why you chose to leave your retirement plan to a beneficiary through your trust. Here are a few of the common reasons. Stretch out. Unfortunately, it wasn't uncommon for a beneficiary to unintentionally take all the funds out of a decedent's retirement account in year one and roll it into the beneficiary's own IRA. The problem was this is treated like a full distribution of the account, 100% taxable, and then an investment in a new IRA which couldn't be touched without paying a penalty until the beneficiary turned 59 and a half. Leaving a beneficiary the retirement account through a trust reduced the risk of this happening. Additionally, some clients wanted to mandate stretching out the withdrawals because it took the client so long to save that money, and they wanted to prevent the next generation from doing anything but maximizing the benefit of the account. Asset protection. By leaving the retirement account to the heir through the trust, creditors of the beneficiary could not take the retirement account from the beneficiary in a lawsuit, a divorce, or a bankruptcy. Bloodline planning. By leaving the retirement account to the heir through the trust, if the heir died, the beneficiaries of the trust are the heir's children or the decedent's other children, keeping the benefits of that retirement account in the family instead of it being left by the heir to a surviving spouse or other person outside of your family. Second family situations. Sometimes in second marriage situations, the account owner wanted to provide his or her new spouse with an income from the retirement account for life of the surviving spouse, but make sure that any amounts that were left in the retirement account at the surviving spouse's death transferred to the account owner's children from a prior relationship and not be gifted by the surviving spouse to someone else. A trust could accomplish this. Estate tax minimization. Because the Massachusetts estate tax exemption is only $1 million per person, occasionally, when a person's retirement account is a significant portion of an individual's wealth, estate tax will have to be paid at the second death of a married couple unless a portion of the first spouse to die's retirement account is funneled through a family, or also called a bypass trust. The family trust allowed the surviving spouse to use the accounts, but the assets held by the family trust, including any retirement assets, are not included in the calculation of the taxable estate of the second spouse to die. Because the surviving spouse could still stretch out the withdrawals over the surviving spouse's lifetime, there was not an income tax problem created by sending a retirement account to a surviving spouse through a family trust. And special needs trust. Again, for many people, their retirement account is a major portion of what they have to leave their heirs. Unfortunately, leaving a retirement account to a disabled individual is likely to cause that person to lose government benefits. Leaving the retirement account to a disabled individual through a special needs trust preserves the government benefits while still allowing the account owner to provide for that disabled loved one. So there are some potential problems created as a result of the Secure Act that you should probably consider. If you don't review your estate plan, these could crop up. Because there's no required minimum distributions, a beneficiary who's not paying attention could leave all the money in the account until year 10 and then take it out all at once. That could cause the funds, because they're coming all at once, to be taxed at that person's highest income tax rate. So you have to pay attention and do some tax planning when taking out benefits. Most existing trusts, if you left your retirement account to a beneficiary through a trust, most of the existing trusts mandate that as funds are withdrawn from the retirement account, the trust must pay those funds immediately out to the individual beneficiary. This mandate was required under the law in order for the required minimum distributions to be allowed to be stretched out over the beneficiary's lifetime. The mandate didn't cause any concern because the funds came out of the retirement account slowly over the beneficiary's lifetime or in lumps for a particular purpose, like buying a house or paying for a wedding. The bulk of the funds remained in the retirement account within the trust where they grew income tax deferred and where the benefit you were seeking by leaving the retirement account to your beneficiary through the trust was accomplished. Funds taken out of the trust and distributed to a beneficiary become the beneficiaries to do with what they wish. The funds are no longer protected from the beneficiary's creditors. They're available to leave to non-family beneficiaries and are included in the estate of a surviving spouse. Therefore, the longer the funds stay in the retirement account in the trust, the longer we are accomplishing your goals. The intention was for the funds to come out and be spent by the beneficiary as needed, while leaving the remaining balance in the trust for as long as possible. Now, because of the law change, all funds must be withdrawn from the retirement account within 10 years of the account owner's death. This causes, in most trusts that mandate all withdrawals from the retirement account to be immediately distributed out of the trust to the beneficiary, it means that the goal you were seeking by leaving the retirement account to a beneficiary through a trust will be lost after 10 years because all of the money is out and back in the hands of the beneficiary. Since lifetime stretch-out is not available to most beneficiaries any longer, the clause mandating that all distributions from a retirement account must be immediately paid out to a beneficiary is no longer required. Trust can be amended to say that distributions from the retirement account to the trust are not required to be immediately distributed to the beneficiary. Therefore, even though the funds must be withdrawn from the retirement account within 10 years of the death of the account owner under the new law, those funds could remain owned by the trust. The withdrawn funds could be placed in a post-tax savings or brokerage account in the name of the trust. Then, when the trustee believes the beneficiary needs the funds, they would be distributed to the beneficiary at that time. While the tax-deferred growth of stretching out retirement withdrawals is lost, regardless of whether you leave it to a trust or directly, the benefits that you are seeking by leaving your retirement account to your beneficiary through your trust can be maintained by making a change to your trust and allowing for the benefits to be accumulated within your trust. But it comes with a serious potential problem. Prior to the Secure Act, because the withdrawn funds were distributed immediately to the beneficiary, the withdrawn money was reported as income on the beneficiary's personal income tax return. That beneficiary paid the tax at the beneficiary's personal income tax rate. Individuals don't reach the 37% tax rate, that's the federal rate, you also have a 5% state tax, until they have taxable income of about $510,000, or married couples income of about $612,000. However, if your trust is changed to allow for the money withdrawn from the retirement account to remain in the trust, then income must be reported on the trust tax return, income tax return, and it's taxed at the trust income tax rate. Trusts pay income tax at a much higher rate than individuals, 37% on any income above $12,950. This higher income tax rate must be considered when deciding whether or not to change your trust. This is where financial planning can make a big difference and why all your advisors should act as a team to help you make the best decisions. There are financial planning strategies that could mitigate the higher income tax costs. This could result in your accomplishing your goals in spite of the Secure Act changes if you update your trust and do financial planning. This is why we asked Anthony to be here to educate you a bit on some of these options. Is my estate plan impacted by the Secure Act? We've reviewed the major changes in the law. The loss of the stretch out will impact how much money your beneficiaries actually receive from your retirement account, regardless of how your estate plan is structured. Anthony is going to speak on this a bit more. In order to know if you're impacted, the first question to ask yourself is, did I leave my retirement account to a beneficiary through my trust? You can check this on your retirement account statement or by calling the company. If the answer is no, your estate plan isn't directly impacted by the Secure Act, and you don't need to change any of your estate planning documents. If the answer is yes, well then your estate plan may be impacted. It's not definite, but you do need more information. So I'm going to turn things over to Anthony, who's going to explain a little bit more about the impacts of the Secure Act on your financial assets.
Great. Thank you, Michelle. I represent Ameriprise Financial. We are a Fortune 500 company and one of the largest financial planning companies in the world. Your financial plan is essentially the sister document to your estate plan. Your estate plan is generally focused on the protection of your assets and on the distribution of your assets upon your death, whereas your financial plan is focused on the management of your assets and the positioning of your assets to achieve your goals. And those goals will generally include, but not limited to, retirement and leaving money to your beneficiaries. Now, ideally, the two plans are integrated, which is why I work with Michelle's office pretty closely on a number of clients. Periodically, the government will legislate in changes to the financial landscape. The Secure Act is nothing new. We've seen this a number of times. We've seen capital gains rates be reduced over time. We've seen the estate tax threshold in my career when I got started at $1 million for the federal level. Now it's $22 million per couple. So what you need to do as an investor is to look at how these changes in the financial landscape impact you. If there are disadvantages once the rules have changed, you want to address those. And then you also want to consider, are there any ways that I can leverage these rule changes to my personal advantage? So having said that, let's turn specifically to the Secure Act. And we'll start with the most simple change, which is the extension of the required minimum distribution age from 70.5 to 72. The government's doing this essentially because they feel that we are underfunded as a society for retirement. So they're trying to give us some more room here to accumulate into plans. So if you have a retirement income plan that is drawing $25,000 for both a husband and a spouse from their retirement accounts as part of their retirement income plan, now you're going to want to take a look at that more closely. It's in your advantage to leave that money in those retirement accounts up until age 72, but that's going to leave you with a $50,000 funding gap in that plan for those 2 years. So you're going to want to redo your financial plan, find other sources of income to fill the gap, and take advantage of the tax deferral that the government has now extended to you. It's not a big change, it's a subtle change, but you certainly want to leverage that to your advantage. The second component of the Secure Act that we're getting a lot of feedback on is the stretch rule, and Michelle talked about that extensively. So now that the money needs to come out more quickly for the contingent beneficiaries, there are a number of strategies that are being discussed and investigated on behalf of most investors. One thing we're seeing a lot of now is people considering converting their entire IRA to a Roth IRA prior to distribution age. And the thought here is to pay taxes today on a smaller amount while our tax brackets are relatively low, so as to not have to pay any tax on a larger amount when the distributions from the Roth IRA come out at the end. The Roth IRA for you and your spouse while you're alive also have no required minimum distribution. So you're going to be able to enjoy the full benefit of that tax deferral, especially if this is an asset that you don't need to draw on, meaning you have other sources of income and assets. Now you can extend this out to your life expectancy, or to when you actually pass, which for most people is in their 90s. That's a substantial tax gain that you get, and the price you have to pay for that is paying your taxes up front now. There are also some more intricate and complicated strategies that are being discussed for a lot of financial plans. Some of these involve insurance planning, and generally, these insurance products are a little bit more complicated than most other financial tools. But we'll just look at a quick example of what can be done in that way. But the important thing is to try to get the concept here and not worry so much about the individual insurance product. So you can see in the hypothetical, we have a couple that will have about $800,000 plus in their IRA. The way it stands currently, if they do no planning, they will give the government will actually end up being their biggest beneficiary of their IRA, right? Each of their two daughters receives just under $300,000, whereas if they leave things the way they are, the government gets over $300,000. I'm sure most people like the government, but I don't know that anybody wants them to be the greatest beneficiary of their retirement account. I certainly don't. Now, the second slide, and we call this a 9-circle presentation. So the first slide was the first 3 circles. In the second 3 circles, what the investor is doing is using their distributions to fund a universal life insurance policy. And what they've been able to do here is now maximize the amount of money that goes to their beneficiaries after tax and reduce the amount that the IRA gets. There's even some modeling we're doing where people accelerate the distributions from their IRAs while they're still alive in order to fund a greater size policy and maximize the post-tax distributions to their beneficiaries. If you look at the third set of 3 circles, this is where they're using the insurance to both pass on money tax-free to the beneficiaries and also leave the balance to a charity. In this case, you can see the IRS has been eliminated or disinherited from the entire process. The government gets 0, your beneficiaries get $800,000, and your charity of your choice gets over $800,000. I think these are things that appeal to most people with wealth. So, in closing, all of these things and whether these strategies fit you and appeal to you are going to depend on your personal circumstances. It's going to matter what your age is, what your income is, what your net worth is, the age, structure, and number of your beneficiaries, the tax bracket of your beneficiaries, your charitable inclinations, and so on. There's no way in a forum like this or any other that I could prescribe advice for you specifically without knowing all of those details. So that if you walk away from this discussion with one concept, it's that come in. If you don't have a financial plan, come in and get one. If you do have a financial plan, visit with your advisor and see if any of these strategies are going to make sense for you. Thank you. I'm going to hand it back over to Michelle now.
Thank you, Anthony. That was very helpful. What you should do now, what should you do? Today's presentation is very general. Our goal is to educate you about the changes that could potentially impact you, but it's impossible to definitively explain the impact of the Secure Act on your individual situation in a general presentation. We recommend that you first identify if a trust is the beneficiary of any of your retirement accounts. If you leave all your retirement accounts directly to individuals, then you probably do not need to update your estate. You do not need to update your estate planning documents in light of the Secure Act. You don't need an appointment. If you did leave your retirement account to a beneficiary through a trust, you need to remind yourself about why you did this. What was your purpose? What are your options? First option is to do nothing. Many of you will not need to adjust your estate planning documents or your investment strategy. But I think this should be a choice you made because you know the changes aren't necessary after learning about the impact of the Secure Act on your personal situation. Change your beneficiary. For some of you, the reason you left your retirement account to a particular beneficiary through a trust was important, but in light of the higher income taxes that would be due on withdrawals from the retirement account if you changed your trust, you may conclude that you should just leave the retirement account directly to your beneficiary, even if it means not accomplishing your original goal. In that case, you would only need to change the beneficiary designation from the trust to the individual beneficiary. You would do this with the financial institution that holds your retirement account. Implement some type of financial planning. It may be that you can achieve your goals not through changing your estate plan, but by implementing a financial plan that makes your current estate plan work. This requires coordination between your lawyer and your financial advisor. Amend your trust. For some of you, the reason that you left your retirement account to a particular beneficiary through your trust is strong enough that you'll want to change your trust, even though it could mean higher income taxes paid on the withdrawals from the retirement account. If you decide to amend your trust, there are likely some financial planning strategies that could be implemented that could reduce the high income taxes due if payments are made from your retirement plan to your trust. For you to get the best results, your attorney and your financial advisor should work as a team. Next steps. If you're an existing client of Surprenant Beneski and you believe you need a consultation because you left your retirement plan to your beneficiaries through your trust, then we invite you to come in for a 30-minute consultation for a discounted price of $150. This price includes the 30 minutes attorney preparation time we need to prepare for your meeting and a 30-minute consultation. In order to make that consultation productive, you should bring to the consultation a current statement for each of your retirement plans, current proof of your beneficiaries on your retirement plan, a blank change of beneficiary form, and a copy of your trust. What will we do at the consultation? We'll review and confirm the reason why you chose to leave your retirement account to your trust, assist you to determine which of the options discussed in this program is right for you, and assist you in changing your beneficiary if necessary and if you bring the form to the meeting. If you need to amend your trust, there'll be a separate charge for that work. If you are not an existing client of Surprenant Beneski, you're welcome to come in for an initial consultation with one of our attorneys. We cannot review this one issue in a vacuum, so this appointment would be for an hour and a half, at which time we would review your entire estate plan. At the end of the meeting, we would make recommendations to accomplish your goal and quote a flat fee for any work. Regardless of whether you need a consultation with an estate planning attorney to review your plan, you should have your plan reviewed by a financial advisor. The Secure Act will impact how much your heirs ultimately receive from your retirement account. A good financial planner like Anthony can help make sure you accomplish your goals. And now we're going to take some questions.
Okay, as a reminder, at the end of this session, you will receive a survey where you can express your interest in the next steps that Michelle covered before the Q&A. Please go ahead, and if you have any questions, submit them through the Q&A function. Our first question. Our trust includes all of our assets, house, banks, IRAs, etc., to be distributed to 3 dependents. At our death, I assume that all assets will be added up and split 3 ways. The IRA is dissolved, and the monies included are in the payout. Is that correct?
As any attorney likes to say, it depends, but I'm going to make some generalizations here. Presuming that your trust is the typical, what we call conduit trust, where the IRA payments are distributed immediately to your beneficiaries, what probably, and assuming that your trust says at your death to immediately distribute trust assets to your heirs, not to hold them for your heirs' benefits, then in that case, the non-retirement assets would be liquidated and immediately distributed. The IRA assets would be divided into 3 shares, and your beneficiaries would receive their required minimum distribution over their lifetime, taking out additional amounts as needed. At least that's how it used to work. Now, under the new law, it would be divided into 3 shares, and those payments would come out over 10 years. I hope that answered the question.
Okay. All right. Our next question. Can a look-through retirement trust be converted to an accumulator trust by deleting certain provisions and adding new appropriate provisions?
Yes. So that is when I was talking during the presentation about changing your trust. That is what I meant. You can change your trust from a see-through or conduit trust to an accumulation trust through an amendment, and then your trustee would no longer be required to distribute the amounts withdrawn from the retirement plan immediately to the beneficiaries. However, if you make this change, there will be income tax consequences.
All right, moving on to the next question. Does a trust still avoid mass estate tax?
So a trust with provisions to minimize and sometimes eliminate estate taxes will still do that. However, in your individual situation, to the extent possible, we try to avoid having your retirement plan run through what we call a family or a bypass trust. It goes directly to your spouse, or through the marital portion, it is included in your spouse's estate. Because of the Secure Act change, if you were planning on sending a portion or all of your retirement account to your spouse through one of those estate tax minimization trusts, a bypass or family trust, you really need to reconsider that. The estate tax on that retirement account going to your spouse is 20%. The income tax that will be on that, if it comes out to your spouse through the family trust, is 37%. So you're probably going to want to change your plan, and you may end up paying more in estate taxes, but that might be the right answer because it's less in income taxes.
All right, here is our next question. Please define chronically ill for purposes of stretching out distribution.
So that's a great question. The government hasn't told us yet. We think it's going to mean people who have things like Parkinson's, Alzheimer's, things like that. Do you have any more information on that?
No, like you said, the responses to a lot of this are evolving. I think if you can make a good medical case for someone being chronically ill, I don't think that's the kind of thing that will be challenged too closely, as long as it's legitimate.
So the question in my mind that they haven't answered that I think is a chronic illness, but I don't know if will qualify as diabetes. So many hundreds of millions of people are living with diabetes. So if your child has diabetes, can you get them out of the 10-year rule? I don't know the answer. As soon as I know, I'll let you know. Here's a question. Does the 10-year rule apply to a surviving spouse? If you leave your retirement plan directly to your surviving spouse, not through a trust, then your surviving spouse can take required minimum distributions over your surviving spouse's lifetime, and the 10-year rule doesn't apply. But if you leave your retirement account to your surviving spouse through a trust, such as a family bypass trust, tax trust that I was just talking about, or maybe in that second marriage situation that I was talking about earlier in the presentation, then you're going to be subject to the 10-year rule. And we have to figure out what's the right thing for you to do in that situation.
Okay, here's a reminder. If you have any outstanding questions for Anthony or Michelle, please send them in through the Q&A function on your presentation. This looks to be our last question. We have approximately 1.3 million total assets, house, etc., 2 dependents, and a small pour-over trust due to capital. Is it likely we have issues?
Since your estate, and this is, we have to look specifically at your situation, but since your estate's about 1.3 million, if your non-retirement assets are more than, say, 350, 400,000, then you should not have a problem. You could leave and I would recommend you leave your retirement assets directly to each other. We'll have your house and brokerage accounts and bank accounts in your trust, and when the first spouse dies, we should still be able to eliminate that estate tax. But that's very fact-specific, and I'm just going from the hypothetical in the question.
Okay, last call for questions. If you have any other questions, please submit them through the Q&A function in the presentation.
We are getting one question. We're just waiting for it.
Okay, I am the beneficiary of a stretch IRA and have been taking my RMDs for several years. Does the new law affect me?
No, it does not. So anyone who was subject to RMDs prior to January 1st of 2020, meaning whoever left it to you died last year or earlier, is under all the old rules, and you can continue to stretch out those RMDs over your lifetime.
Okay. The next question is, if a surviving spouse is the beneficiary and then designates their children as beneficiaries after the IRA owner's death, does the 10-year rule then take effect upon the death of the surviving spouse?
If the surviving spouse rolls the IRA into the surviving spouse's own name, the surviving spouse will then take those distributions over the surviving spouse's lifetime. At the surviving spouse's death, when the IRA is then left to the heirs, presumably the children, but whoever, those people will then have to take the money out over 10 years.
Okay, the next question is each beneficiary subject to the max $1 million amount?
Yes. So any Massachusetts resident who dies is subject to estate tax, and that is calculated based on what that person owns at their death, regardless of where they got it. So they may have accumulated it themselves or they may have inherited it. But if they have more than $1 million in property, they're going to be subject to estate tax.
Okay, our next question says, wife and I have a revocable living trust. All retirement accounts list spouse as primary and 2 children 50% secondary beneficiaries. Do I need to make any changes?
This is what I was trying to get to, and I apologize if I wasn't clear, but it doesn't sound like you would need to make any changes in that situation because you've left your retirement account directly to individuals, not to a trust. So your estate planning documents are not impacted at all and would not need to get changed.
Okay, this looks to be our last question. Since the government has not identified all issues, would it be best to wait and amend our trust once we review it?
They haven't identified certain issues related to who is a chronically ill individual, but I think for just about everybody else, it's clear this 10-year payout rule is going to impact you if you have a trust, which is what we call a conduit trust, where the payments have to go directly to your beneficiaries, and you're probably better off reviewing that now rather than waiting, because you will be impacted.
All right. That looks to be the end of all of our questions for today. Of course, if anything comes up, feel free to call our office at 508-994-5200. But as soon as we close out this presentation, you will receive a survey, and that is where you can let us know if you are interested in booking a consultation either with Anthony Salerno from Ameriprise or with one of the attorneys from Surprenant and Beneski. Thank you so much for attending today's webinar. And as a reminder also,
just want to mention the consultation at Ameriprise, just to overview your situation, is complimentary. There's no cost or obligation to that. So it doesn't cost you anything to take a look at where you are, and then we can proceed from there.
Okay, so if you do want to go ahead and book a consultation, you'll be receiving that survey shortly. And if you still feel that you want to get this presentation perhaps another time, check our website. We have plenty of in-person sessions coming up in the next few weeks. Thank you again for taking the time with us today.